the court order, all children that are entering the first grade may enter the school nearest his home.
We'll make the Declaration of Independence read in the words it was written in. If they'd leave us alone and quit brainwashing the colored people, we'd solve that ourselves. I believe that this segregation must be maintained throughout the width and breadth of our great state.
There were some guys who were just there in the beginning, so to speak, and that's where Tureaud was.
He wanted to find change in the law and through the use of the law to bring about change.
Every action taken by the NAACP, every action fought by Toro and the great black lawyers, both black men and women in the nation, have always had a dual purpose: economic liberty and individual liberty.
A.P. Tureaud believed completely in the legal system, and he thought that the majesty of the law would always prevail eventually.
He knew he could not do things alone, and he did not want to do them alone because there was no glory that he was seeking.
The Negroes had nothing to fight with. They didn't have any of the materials of war. They only had themselves and whatever persuasion they could bring to bear by group activity or something like that. We in Louisiana had to depend upon our own resources for whatever gain we could make.
"40 years after the Civil War, New Orleans, like other southern cities, was still in the process of reconstructing its political, social, and economic order. Former slaves who had rejoiced in their long-anticipated freedom were free physically, but not economically. They asked, how do we find our way among those who once owned us? How do we provide for ourselves and our families? We're free, but we have no property, no money, little education, and no jobs. Those who could not support themselves on the land moved to the cities. Free people of color had once enjoyed a middle ground between slaves and white persons. Now their education, property, money, and livelihood provided a weak shield from increasing white prejudice and discrimination. Following a brief period during Reconstruction, under the watchful eye of the federal militia, former slaves and free people were allowed some political and economic inroads. Immediately after the rollback in federal intervention, white Southerners constructed codes and passed legislation to limit the rights of all people of color. These state mandates, known as Jim Crow laws, established segregation in the South. Because of these laws, former slaves and free people of color were denied the equal rights extended to all citizens following the Civil War and the abolishment of slavery. In Louisiana, a large number of the free people of color were known as Creoles. The term Creole often was used to describe persons with a mixture of African, French, and Spanish blood. Canal Street symbolically separated the Creoles from the black residents who lived uptown. The Louis Tureaud family was a part of New Orleans' Creole community and lived 1 block below the French Quarter in the 7th Ward. Louis Tureaud was a self-employed carpenter who specialized in installing cisterns and spiral staircases in the French Quarter. His wife, Eugenia Tureaud, worked as a domestic outside of their home. Like other Creole families of the 7th Ward, the Tureauds worshipped at St. Augustine's Catholic Church. White and black Catholics attended Mass together, but black parishioners did not enjoy full privileges.
Back in 1890s, the Archbishop then had begun what were called the separate black schools and separate black churches because he said this is the best way to give blacks education.
Louis and Eugenia Tureaud attended New Orleans schools during the time of Reconstruction, when black and white students were enrolled together. Later, their own children were to attend a segregated parish school. Homer Plessy led the challenge against racial segregation when he refused to leave his seat in the white coach of the East Louisiana Railroad. A lawsuit was brought by the Citizens Committee for Colored Creoles. Instead of ruling to abolish Jim Crow laws, the nation's highest court sanctioned them.
The Supreme Court of the United States affirmed that Louisiana could separate blacks in transportation, facilities, and services. Separate but equal originated in Louisiana. There's no question about it. And all blacks, no matter what color they were subjected to that. In fact, Plessy was only like 1/16 black. So obviously looked like a white man. Tureaud looked like a white man. But they were subject to discrimination the same as anybody else.
Alexander Pierre, one of 11 children of Louis and Eugenia Toro, was born in 1899, 3 years after the Plessy Decision. Segregation and discrimination became a way of life in the South. The Tureauds and other black families lived within these restrictions, but they never accepted them.
His mother and his siblings had a very hard time, and they could never acquire a job here in New Orleans, and they had to leave because they were all laborers and contractors and carpenters. And my dad was the only one that completed his education, and he always wanted his brothers and sisters to stay here in New Orleans, but they couldn't because of the injustices that they had set up here.
In the Jim Crow South, employment opportunities were increasingly dismal for black residents, and many, including Louis Tureaud, migrated to the industrial North. His son, A.P., joined a larger migration years later during World War I, when black Southerners replaced white workers who had joined the war effort.
Chicago was by no means for him some kind of a paradise. The only thing that really struck him as much different was that he could ride freely on the public transportation, on the streetcars of Chicago. Now that meant something to him, of course, but Chicago also was a place of deep discrimination.
The jobs open to black workers were menial. A.P. Tureaud worked in the Illinois Central Rail Yards, where he made $1 an hour and was on 24-hour call. Despite the problems in Chicago, Tureaud saw that African Americans were moving to make changes in their lives. Voter registration drives were in full force, and Oscar DePriest, who later became the first black congressman since Reconstruction, was speaking out. Frustrated with his job, Tureaud left Chicago on the eve of the 1919 riots to join relatives living in New York. A.P. settled in Harlem between 5th and Lenox on 132nd Street. He and his brother Adolph worked as dishwashers by day and by night as stage actors with the Lafayette Players. While in New York, A.P. and his brother met with jazz great King Oliver, a fellow New Orleanian. Because of jazz, being from New Orleans was in vogue. In New York, Tureaud witnessed the campaign for an independent black nation urged by Marcus Garvey. He watched, but was not particularly impressed by Garvey, as were some in his circle. He also witnessed the activities of the newly formed National Association for the Advancement of Colored People, the NAACP, which was headquartered in New York. After 1 year, Tureaud moved to Washington, D.C. to take a job as clerk with the U.S. Justice Department's law library. He became fascinated with the workings of the nation's judicial system, its power and influence. Tureaud came into contact with people of literary and legal ability that gave him an outlook on life he had never dreamed possible. Howard University's law school in Washington, D.C. opened in 1869 for black students who were interested in studying law. Tureaud enrolled in Howard's 2-year evening program and kept his job at the Justice Department.
A.P. Tureaud's classmates were probably like him. Many were from the South, but not all of them were from the South. Some of them were persons of means. Their parents had been second-generation graduates, And he was in the metropolis of intellectualism of a black university, and he brought some intellectualism with him.
Tureaud's college days also included an active social life. He joined Alpha Phi Alpha fraternity and wrote about the capital's social scene for a local newspaper. Tureaud's college roommate was Eugene Davidson, the son of an activist in the Washington, D.C. branch of the NAACP. At the Davidsons' home, Tureaud was introduced to noted NAACP organizer W.E.B. Du Bois. Tureaud joined the NAACP after a rousing speech by the poet James Weldon Johnson at the Howard Theater. Tureaud developed both socially and politically at Howard and came away with an outstanding legal education.
His professors were very powerful men. He had classical teachers, bright teachers, and teachers that were well respected among lawyers and people throughout the country. James A. Cobb, for example, had been an assistant attorney general of the United States. He had litigated cases before the U.S. Court of Appeals. And so Cobb was a person that everyone knew, admired, and respected as being a brilliant constitutional lawyer, and he was guided by these teachers throughout his law school days.
Tureaud closely studied the U.S. Constitution, all the while seeing constitutional rights, especially those guaranteed by the 14th and 15th Amendments, flaunted so brazenly in the South. In 1925, Tureaud witnessed the historic Ku Klux Klan march on the nation's capital. Even though he dismissed it as more amusing than impressive, the full import of this event was not lost on the young lawyer. The law could be a potent agent for social change, and Tureaud knew that change was needed in his native Louisiana. New Orleans was still racially segregated when he returned in the mid-1920s. 30 years earlier, separate but equal had become the law. Black Americans were kept separated from white Americans and were denied equal opportunities. Thanks to Walter L. Coyne, a Creole leader in Republican politics, Tureaud was given a job at the U.S. Custom House in New Orleans. The Black and Tan was a political force in New Orleans, made up of black and Creole Republicans. They led delegations to national conventions and held key positions in the U.S. Custom House. Tureaud benefited from the longtime presence of black Creole leadership in both politics and law when he returned to his hometown. Along with his job at the Custom House, Tureaud struggled to establish a private law practice. It was a time when even black clients were cautious about hiring a black lawyer.
I think the people felt that a white mouthpiece was more effective than a black mouthpiece in the courts because they knew the judges and they knew their way around and they were not isolated like Mr. Tureaud probably was, and I think he must have felt very much alone.
A lot of black plaintiffs felt that a black lawyer was going to be discriminated against by white juries or judges, and a lot of them had absorbed the stereotype that the black lawyer was not competent.
It was almost unheard of for a black person to aspire to be a lawyer. As a matter of fact, in a number of situations when I said, look, I'm going to be a lawyer, members of my own family said, well, you know, what are you going to do? Are you going to stay here or are you going to leave? Thinking that the only way that one could be successful would be to leave New Orleans. As a matter of fact, a number of them thought that I ought to leave if I insisted on being a lawyer.
It used to be kind of agonizing to see a Negro come to you with a little $5 claim and in a half an hour come back and get his claim because he talked to somebody about he went to a lawyer, and when they found out it was a Negro lawyer, he'd come back and get his claim because they didn't think a Negro could handle his case.
He became quite skillful as a civil and criminal lawyer in a general sense. I mean, he handled property cases, will cases, criminal cases, and he did this sort of part-time.
The Knights of the Pythian Temple was a popular gathering place for Seventh Ward residents. While attending a social, Tureaud met Lucille Dejoie, a graduate of Howard University School of Pharmacy who worked in her father's drugstore. They were married after a brief courtship.
You didn't meet many professional black women in those days either. So about two-family income, they had it. I mean, people are constantly amazed that both husbands and wives are in professions today. Well, you know, that's always been true, so to speak. That's nothing really new. There weren't as many, so people thought it didn't happen, but they were a professional couple, black couple, and that's got to be 60 years ago when they started out. They were unusual in that sense, I think.
The Tureauds settled into their first home on Rushablave Street. They became longtime residents of the 7th Ward and active in their neighborhood.
You know, he had 6 children, and he was very much a family man. In fact, I think until his children were grown, he would get up and cook breakfast for them. And a real old country breakfast, you know, grits and eggs and bacon. And I remember my husband used to kid him every now and then and said, "Did you get up and feed your gang?"
He was a soft touch, really, with us. And we could always get our way with him. And I knew that if I ever wanted extra money to buy anything, I would go to my father. I would never go to my mother. Never.
Even with his busy schedule, we never missed him. Never. He was always here with us. He supported us 100%.
He loved to travel, and we would take trips every summer, and I, as the only son, used to get to go on many trips with him to New York, to Chicago, to Alabama, to Baton Rouge. I remember once I got to meet Haile Selassie, Emperor of Ethiopia.
Even when all of us were blossoming as lawyers, and by that I mean we were gaining a reputation, we were making a little money, A.P. Tureaud still drove a Ford, still made sure that his family understood that they were going to live in the home that he was providing for them in a community where they had lived all of their lives.
A few years after Tureaud returned home, the entire country was hit by the Great Depression. Dire economic conditions plagued most Americans, both black and white, and basic daily survival, finding enough food and adequate shelter, became the struggle.
In the masses of America, 75 to 80 to 85% of the people not only give up their property year after year, but they go further and further and further into economic slavery.
He was sharp and brilliant, and he knew how to handle the people. He was a great mind, legal mind as well as a political mind. He gave us a kind of a leadership around here that had the poor people believing that everything he was doing was for the poor. A lot of it was for himself, but he didn't make a darn thing out of it because everything he got, he either threw it away or he spent it on politics trying to achieve his goal, political goal.
Competition for jobs heightened the tension between the races. The few available opportunities were controlled by white persons through discrimination and intimidation. Klan activities escalated during this time, while human rights activities were virtually absent. Not until after World War II did the fight for rights in America begin to pick up.
After the creation of the NAACP Legal Defense Fund, the movement and the coordination of Charles Hamilton Houston, there was a new breed of lawyer being graduated from law schools across the country, including Howard University, who said they weren't going to take it anymore and who were more aggressive. But they also had the support of other lawyers outside of the states in which they resided. So to that degree, he was a new breed of civil rights lawyer.
There were only 4 Negro lawyers in New Orleans and 5 in the whole state. The others were not active in NAACP work. I started out with NAACP work from the very first day that I was admitted to practice law.
The NAACP had planned the strategy and the type of cases they wanted to bring in order to eliminate Jim Crow. On the other hand, the question was, are we going to follow the dictates of the NAACP on how to litigate these cases, or are we going to continue to work things out as Southerners? Thurgood Marshall was viewed affectionately as a troublemaker to Southern lawyers.
Here and there, we read and hear urgent pleas for understanding of the race problem in the South, especially pleas to let the Southerners work out the problem themselves, quote, without outside opposition, end of quote. I suggest that, quote, letting them work out their own problems, end of quote, means simply letting them continue forever their peculiar pattern of prejudice as usual.
Tureaud was one of the reliable Southern lawyers that we had. When we wanted cases to be brought down there, Tureaud would be our local representative. And he was always willing to bring these cases.
It took a lot of courage in those days to identify publicly with the NAACP. As Thurgood used to say, he's putting his life on the line. We're getting the next plane out of here, but he has to stay here and face whatever reprisals there might be for our activity.
Most people have not given him credit for the contributions that he made to men like Thurgood Marshall, so that when Thurgood Marshall came down to New Orleans to handle a case either in the District Court or the Fifth Circuit Court of Appeals, Thurgood Marshall had the preparation and input of A.P. Tureaud.
The Campaign for Human Rights needed to broaden its base of support. The first step was made at the local level by Toro and other black leaders.
We put up our own money and started a newspaper, the Sentinel, and that's how the Sentinel began. It was in protest to the existing newspapers.
It got to be pretty expensive for them because they had to pay with money out their pocket, plus they had to work. In other words, they had to fold the paper, stuff it, deliver it, and mail it too at their expense.
Our first big case was to get some black managers for the housing project. They were about to open the Magnolia Housing Project, and we said that it was going to be exclusively for blacks. They should have at least have a black manager, have a black office force. And we got 5,000 people who pledged that they would not move in the housing project unless they had black managers.
The housing project wasn't the only breaking story for the Sentinel. Where other papers ignored NAACP investigations, the Sentinel fully reported each case.
John Jones and his cousin, Sonny Man Washington, was supposed to have been peeping in the people's house. Jones had just come back from overseas. They beat Sonny Man, and he pretended to be dead. They used a blowtorch on Corporal John Jones and used a blowtorch on all of his genitals and everything. They killed him, and we got the whole story. And the Pittsburgh Courier had sent 2 men up there. They came running in. Oh man, said, glad to see you all. Don't go in this town. We got to leave. We've been ordered to leave town. And we don't have a story. We didn't get the chance to interview anybody. So we said, what did you do? Well, we went to the sheriff and told him we were newspaper men and we come and place ourselves under his protection while we investigated. And it said, the sheriff told us, said, you crazy. You must be crazy. You better go on out back to New Orleans. I can't protect the niggas I got here now. I said, you see what happened to one of them?
Information gathered by Tureaud and his team brought 5 men to trial in Webster Parish. There was an eyewitness testimony.
They found the defendants not guilty.
almost a daily and nightly experience for me to get threats at home, my family and everybody else. They'd call the neighbors and tell me not to sleep home at night because my house was going to be bombed. And they threw a lot of stuff on my doorstep, or on the door.
We used to get crank calls and they would say they're going to bomb the house. My two older sisters, Sylvia and Carol, their bedroom was on the front of the house. And we used to tease them, and I'm sure they didn't always think it was funny, but that when the bomb was thrown on the front porch, they'd be the first to go.
That was one of the worst times for me. And a big boom hit the front window and shattered the glass, and I tell you, to die would have been easier. We found a baseball. Kids on the corner were playing baseball, and it just at that time, if they had done it before, we wouldn't have paid any attention to it.
We used to keep a whistle by the phone. It was for the vulgar calls and the cursing and the name calling. And we'd answer the phone, and we always answered White Plains 53816. That was our standard way of answering the phone, just to make sure people knew the number they were calling. And if they started cursing, we'd just pick that whistle up and blow as hard as we could into the receiver and hope that it had hurt somebody's eardrums.
If they'd leave us alone and quit brainwashing the colored people, we'd solve that ourselves. Yes, I like colored people. And I know there ain't many of them can vote in Gina either. And I ain't saying this for votes. I'm the best friend the colored man, and the poor white man, and the middle class, and the millionaire, if he wants to do right, ever had in the governor's office in the history of this state. You just check. You just check.
Earl Long's term as governor polarized Louisiana politics. Both he and his brother Huey de-emphasized race as a political issue and pursued the support of black voters. Earl Long said, "If those colored people helped build this country, if they could fight in the Army, then I'm for giving them the vote." In reality, the white registrar's requirements often prevented black applicants from registering, and if you couldn't register, you couldn't vote.
The registrar of voters had the power to ask you any question, and read and write and answer any question about the state or federal constitution. Now, that was tough. And they usually applied that part of the standards to black registrars, not whites. The registrar wasn't required to have any kind of education. He could be an educational first grader. And he would make up his mind. He said, "Well, I'm sorry, you failed it." He wouldn't tell you what part you failed, but he'd say, "You failed it," and tell you, "I can't register you."
The 15th Amendment had no meaning in Louisiana. To change that, Tureaud, Marshall, and other civil rights attorneys filed suit against T.J. Nagel, the Registrar of Voters in St. John the Baptist Parish.
The district court ruled that these incidental administrative decisions of the registrar were not subject to judicial review. This case was appealed by Thurgood Marshall and A.P. Tureaud, and the court ruled no, that the court ought to look behind these decisions to see if they had discriminatory effect. That case, therefore, becomes one of the earliest voting rights cases, and it's not often referred to as a great civil rights case.
It was not until 1947 that we actually knocked out the requirements of Louisiana law with respect, or the treatment of the Negroes in registering. As a matter of fact, I was turned down by the Registrar of Voters. He told me that I had made a mistake in filling out my application, but I got registered the next day. I didn't have any trouble with that.
Another issue that occupied Tureaud was the disparity in salaries between white and black teachers. This concern became the first target in the fight against segregation.
The equalization pay cases were a part of Charles Hamilton Houston's plan to desegregate the schools, because it was one of the easiest type cases to establish a violation of the 14th Amendment. And so you will see across the South equalization pay cases being brought by local lawyers and the NAACP, where teachers were not being paid the same to teach the same students.
There was no Negro teacher at that time that was worth the salary of the white teacher. The white teacher was making $150 a month, and we were making $75. We never got new textbooks. We never got new furniture. We always had to cast off from the others, and then we had very adverse conditions under which we as Negro teachers worked.
He filed 16 different lawsuits to equalize salaries for teachers over a period of about 7 years. And no cases did the school board say, hey, we know that we are doing wrong, we've done wrong in the past, and we're willing to settle. Every case they had to go to trial. And that was dangerous.
Black teachers who brought these suits often lost their jobs and were harassed in their business dealings. Tureaud's work with these plaintiffs eventually led to Louisiana's adoption of a minimum salary schedule in 1948 for all public school teachers.
The equalization pay cases were the cases that the NAACP used to achieve what ultimately became Brown versus Board of Education.
The NAACP now targeted the desegregation of public educational institutions based on the separate but equal doctrine. If separate facilities for black students did not exist, then the state's existing institutions must be open to them. Toro filed a lawsuit in 1946 on behalf of Charles Hatfield, who wanted to enter Louisiana State University's law school.
The strategy that we inherited from Charlie Houston was to just make it more expensive for the states, the southern states, and so if they'd have to set up a school for medicine, separate school for medicine, law, journalism, and so forth, they would find that be a little ridiculous, and that they would on their own just open the doors to the school.
Robert Carter and I did the substantive argument insofar as a constitutional violation, and AP also talked about the number of professional schools organized and operated by the state, and there were no Negroes who had been admitted as students. It was one of the greatest thrills of my life at that time, to know that I had a chance to argue a case in a state whereby I had been barred from studying law.
In a summary judgment motion, the plaintiffs' lawyers felt that the judge would rule on their behalf. But before he could rule, the Louisiana legislature opened a law school for black students at the all-black Southern University. Tureaud's suit had forced the issue on separate but equal, and black students were provided a place to pursue a legal education in Louisiana.
AP went through a whole history of the changing of the rules, so to speak, and they never frustrated him, at least outwardly. He just kept plugging along.
The NAACP then successfully litigated a landmark civil rights case in Sweat versus the University of Texas School of Law. Heman Sweat's enrollment in Austin prompted a series of lawsuits against the all-white policy of law schools across the South. In Louisiana, Tureaud prevailed and Roy Wilson enrolled in LSU's law school. Officials there, however, claimed there were problems with Wilson's past military service and dismissed him from the law school on moral grounds. The court's decision for desegregation applied only to the law school. Tureaud was forced to file separate suits to admit black students to LSU's medical and graduate schools. These victories were obtained when Darrell Foister of New Orleans entered the medical school in 1951 and Luttrell Payne of Natchitoches entered the graduate school. Only one segregated school remained on the LSU campus, and it was the largest, the undergraduate school. Attorney Tureaud's son, AP Jr., led the challenge there.
There may not have been anybody else available to go or willing to go. AP maybe he was slightly hesitant about it, but he knew it was something that he needed to do, and he did it.
I was very unhappy. I was the most unhappy person that I knew at that time, and depended a lot on my family to help me. And it was the hardest thing that I ever had to do.
17-year-old AP Jr. was a single black student among more than 20,000 at LSU. His enrollment was challenged by the state, the university administrators, and many fellow students. Some university instructors also voiced their opposition to teaching black students.
There was a lady, she was very prejudiced, and she announced to the class the first day that I met the group that she had never taught a Negro before, and she didn't know how she was going to be able to manage the situation. And I thought that was unnecessary and rude. She didn't even know if she could touch my paper. I mean, she said all these things to the class. And I just thought, how could this be? How could she be allowed to teach with that type of attitude? I was a student. There were foreign students from all over the world there. She taught them. She didn't think anything about correcting their papers. She made me feel almost like I had a disease of some, social disease of some kind.
The LSU Board of Supervisors ordered the university's attorneys to appeal the lower court's decision that admitted Tureaud. The appeals court overturned the lower court since only one judge had heard the case, and young AP was promptly dismissed. The Supreme Court later overruled LSU's dismissal of AP Jr. until it could hear the case. However, AP had already enrolled at Xavier University and refused to return to LSU. By the mid-1950s, Tureaud and the NAACP began to run into difficulties. The Louisiana legislature ordered the organization's branches to surrender their membership lists or be prohibited from holding meetings and conducting business. Revealing members' names would have been dangerous for them and their families, so NAACP National Secretary Roy Wilkins was forced to suspend operations in Louisiana.
Those of us against whom the legislature could not retaliate remained with these groups. AP Tureaud continued to be associated with the NAACP. It was outlawed, but we could still find individual plaintiffs if necessary, or we could organize a group as rapidly as they would close down a group if it came to that.
The U.S. Supreme Court overturned Plessy in 1954, finding that separate educational facilities in Kansas were unequal. In the wake of Brown versus the Topeka Board of Education, racists among all walks of life were vocal in their opposition to integration.
They want to throw white children and colored children into the melting pot of integration, out of which will come a conglomerated, mulatto, mongrel class of people. Both races will be destroyed in such a movement. I, for one, under God, will die before I'll yield 1 inch to that kind of a movement.
4 years after Brown, 200 black students entered LSU in New Orleans. It became the first public school in the South to open its doors as a desegregated institution.
How do you feel about being admitted?
I feel great about being admitted to LSU.
The NAACP, which finances these suits, could very well spend some of that money sending these children to schools where they can get an education without harassing their white neighbors and without putting themselves up as an object of public ridicule and scorn.
There were still discriminatory issues that needed to be addressed on the New Orleans campus. Students were desegregated in the classrooms, but not in the cafeterias.
We had boycotted the snack bar, which was the only eating facility on campus which was open to us. It was operated by Morrison Cafeteria, which did in fact have a cafeteria, which we couldn't go into. And the boycott lasted, I think, about 8 or 9 months, and we called upon Tureaud, presented our grievances. And it struck me that he didn't find it to be as big a problem as we thought it was. He felt that our main job was to get an education. But we insisted that he ought to go back into court and to insist that they open the cafeteria to us. So I think he was reluctant, but he did. And within, I'd say, a month, the lease was revoked and the school began to operate an unsegregated cafeteria on its own.
Tureaud's effort that year also saw the desegregation of city buses and parks.
He not only just did civil rights cases, he organized people. He organized voting. He organized people into coalitions, and he even ran for Congress once, not that he knew he would be elected or wanted to go to Washington. He wanted to show black people that it was possible to elect representatives to represent you, and to show people that the vote mattered and the vote counted.
You know, Mr. Tureaud and Reverend A.L. Davis were political allies. Reverend Davis was the president of an important Baptist association, and he and Mr. Tureaud were part of something called the Orleans Parish Progressive Voters League. He had drawn both on, you know, the Creole community and through his contacts with Reverend Davis and people like that. He developed a constituency within the black community.
My father got involved in trying to organize an interracial council with students and adults from all of the universities in New Orleans. So I came home and I was telling him all about how successful the meeting was, and we were going to do some things together. And he said to me, do you realize who the heroes here are? And I said, what are you talking about? What do you mean heroes? He said, well, think about those young white students. They probably have been ostracized by their friends and maybe even by their families because they are doing something that is just and fair and involves being involved with black students and trying to change the system. He said, to me, they're the real heroes, and you need to appreciate and understand that. He said, you have to do it because you're caught in the struggle. They don't have to do it.
A.P. Tureaud was perhaps 15 years older than those of us who were coming on the scene at that time. He did not encourage us to do some of the things that we wanted to do, like lead people in marches and to carry picket signs and to attack the establishment. A.P. Tureaud felt that you could work with those people.
Louisiana State Bar Association didn't take in blacks. When they agreed to take blacks, they moved the yearly meeting to the Gulf Coast of Mississippi, thinking that that would discourage blacks. Well, AP never looked at it that way. AP went to those meetings, and if he was pushed on the side or told to sit in a certain area, he sat.
Tureaud brought a group of younger lawyers that included Revius Ortique, Ernest Morial, and Robert Collins with him to a meeting, but he found that they had their own agenda.
We were told, we're going to have a special place for you. So special that it was separate and apart from the main dining area. We didn't say anything at all until a few minutes before lunchtime. And then we said, we want our money back because we are not going to contribute to any segregation. Well, A.P. Tureaud was dumbfounded. He says, if you were going to do this, why didn't you tell the people before they fixed up the place? And we, of course, took the position that's what we wanted them to do. Fix it up, go to all that expense, go to that trouble, whatever it is, and then give us our money back. A.P. Tureaud felt that that was wrong, that was impolite, that was ill-mannered, because you were in their meeting. You had volunteered to come to their meeting. They hadn't sent, I can hear them now, they didn't send for you. You came, you paid your money, and now you're going to make this scene. A.P. Tureaud stated, I can understand that he felt that it was much better for him to be able to say to these, it's wrong for you to insist on segregating us, but without creating a scene. We thought it was much better to create the scene.
They thought he was too slow. They wanted him to go out banging and knocking people down, you know, and that wasn't his style. And to the extent that they even called him Uncle Tom, and that one really hurt.
I don't know that being flamboyant and offensive would have worked in the 40s and 50s. I don't think that he compromised himself when he went into court and said sir, and it wasn't in a way that I think demeaned him.
You're under arrest. Get their names.
Student-led demonstrations and public protests had a different strategy for bringing about social change and civil rights during the 60s. Tureaud did not agree with this new strategy.
He saw civil rights progress as a legal issue. We had some heated discussions. I was young then and very fired up by the turn of events with Martin Luther King and the nonviolent demonstrations, and my father didn't always support that approach. I think he later on saw the value of it, and that it did push the legal avenues too, into a more consolidated effort.
I don't think anyone would have ever classified Mr. Tureaud as a radical. The freedom rides, for example, I don't think Mr. Tureaud would have encouraged that.
If you're attacking the system, you're a radical. Nothing conservative about somebody who is attacking the established system, long since established.
I recall that Lolis, Eli, and I, on one occasion, we were criticized by some of the judges at the courthouse because we went into these what was designated as white restrooms. A.P. Tureaud called me in and says, "Look, what are you trying to do?" I said, I just refuse to go into a segregated restroom in the court. I will not drink from the segregated fountains. He says, but you got to remember that if for some reason you lose your license to practice law, then you will not be able to help other people.
I never had to put on one single demonstration, and I've gotten all of these things. Demonstrations haven't desegregated anything but lunch counters. And we had to make it possible for them to carry those on by litigation.
The Bush versus Orleans Parish School Board case was aimed at desegregating the public grade schools. Filed in 1954, it became Tureaud's most publicized case. When the Bush case was reinitiated during the early 60s, all three front-runners in the Louisiana governor's race made the fight against desegregation a major issue.
Under the NAACP's timetable, the Integration Showdown in Louisiana will come right here in New Orleans next fall. Federal Judge Wright has set next March 15th as a deadline for your school board to submit a plan to integrate your schools. According to the Assistant Attorney General of the state of Louisiana, NAACP Attorney Tureaud, you know who he is, told the Assistant Attorney General that the NAACP had deliberately postponed this order until after the gubernatorial election. Tureaud said that bringing the order up right now might elect Willie Raynack governor of Louisiana.
Jimmy Davis was elected governor. True to his campaign pledge, he immediately took steps to ignore the law of the land and prevent school desegregation in Louisiana.
We therefore, without reservation, endorse and approve Governor Davis' assumption of control of the New Orleans schools. Minority forces for integration, with the powerful help of the judicial pen, are waging a strong attack on one of the state's most precious sovereign rights, the right to establish, maintain, operate, and control its own public school system.
At that time, the candidates for the school board were advocating closing the schools rather than integrate. And AP and the committee felt it would be a good idea if we could bring this to the public in order to develop an emotional response to integration. In other words, if we could develop a groundswell of people who wanted their schools opened rather than closed.
The defendants in the case really weren't litigating the merits of the case. They were using the courts as a way of stretching out forever the obligation to desegregate the schools.
The delay probably creates
a bit of uncertainty as to what may be the outcome of the opening of schools, because there has been a threat made about closing schools, and we don't know just what could be the result of this delay in terms of the court's orders that they be desegregated beginning with the first grade in September.
If the judge ultimately rules in your favor on this motion, would this free the school board to plan for possible integration?
Well, I wouldn't want to answer that directly, because I don't know what legal issues could arise from the action taken by the court on the motion which I filed.
Resistance by means of litigation was probably more extensive there than in any other case I can think of. I mean, in other cases you might have got through with 10 or 15 hearings, but in the Bush case it was 37 hearings.
The local judge in the New Orleans public school case was Skelly Wright, who was one of the judges who supported the Supreme Court's decision, upheld the law, which was his duty as a federal judge. The federal judge, in some instances, was the most hostile person in the community that we had to confront. But that was not true in New Orleans, and in that respect, we were very fortunate.
Despite Judge Skelly Wright's repeated meetings with the school board and several deadlines for the board to submit its desegregation plan, little progress was made. Judge Wright then issued his own plan. 4 black girls, escorted by federal marshals, braved the crowd gathered at the school in protest. These young students became the national symbols of school desegregation.
Well, what happened, say, after the first day?
Nothing.
Was she upset?
Not at all.
Does she understand what it's all about, fully?
I don't think she does. I think she's transferred from one school to another.
And what about the other children?
She's taking it fine, too.
Did any of them seem frightened at all?
No, she was very thrilled when she came home.
How about the others? Are they still taking it all right after these last 3 days into this 4th day?
Yes, Mama is fine.
Are you all determined for your children to stay in the school?
Yes,
You're
we are.
determined to stick to it?
Yes.
Louisiana had not yet come to terms with desegregation, nor with A.P. Tureaud, who helped to make desegregation a reality, nor the federal judge who enforced the law of the land, nor with those politicians who were against desegregation. This tension was reflected in the commentary of a media Gridiron Show in 1961.
The case that desegregated the schools in Orleans Parish took 16 years from the date the petition was filed until the date the final judgment came about. AP was on that case that whole time.
New Orleans didn't burn down, but it didn't burn down because people like A.P. Tureaud were here saying to the white community, look, you've got to give. You can't stand still. You've got to give. And he's saying to the black community, that is not the way to accomplish it. The courts are the means by which we can accomplish. So, I think that he made a major contribution. I don't apologize for what A.P. Tureaud was saying and doing. I say that he was making a contribution, one that we all had to depend on.
At the age of 70, Tureaud retired after cancer made it difficult for him to continue working. He began writing his memoirs, but left them unfinished. Alexander Pierre Tureaud died in 1972.
I remember talking with him about 2 months before his death, and you know, his body obviously had been racked by cancer. He had lost a lot of weight, and he was in pain. But he was not bitter. He felt that he had a very, very full and very fulfilling life, and really didn't have any regrets.
I don't know of anyone, white or black, now that will ever say anything derogatory about A.P. Tureaud. I mean, they just won't, because if they don't agree with this, if they didn't agree with the civil rights thing, they agreed with the way he looked at himself as a lawyer in terms of his client, the court, the jury, the opponent, the adversary. Right now we could use more A.P. Tureaud as mentors.
His work opened things up to the extent that lawyers like myself who came along later could both be civil rights lawyers and earn a living.
He also was a person who had a sense of justice and fairness, and he knew that this was not a fair system or a just society, and to limit and to segregate and to categorize people based on their heritage or their color would be unfair. He also was a person who respected intelligence, and that intelligence didn't come in one package of whiteness. It came in all varieties, shapes, sizes, colors, national origins, religions.
In honoring his longtime friend and colleague, Thurgood Marshall said, A.P. Tureaud was a great man. The Lord put you here on earth for three things: to work for God, to work for your family, and to work for your people. And A.P. Tureaud was a master of all three. That man's courage was unbelievable. In this age of civil rights, we got where we are today by the efforts and dedication of men like A.P. Tureaud.
This program supported by a grant from the Louisiana Endowment for the Humanities.